Hi, everybody. My name is Michael Rappaport, and I'm the director of the Center for the Study of Constitutional Originalism, and I'd like to welcome everyone to the 17th Annual Hugh and Hazel Darling Foundation Works in Progress Conference. Each year at the beginning of the conference, I use this time to highlight what I regard as some of the most important events concerning originalism in the past year. This year, in addition to continuing that tradition, I'll also be doing a brief retrospective on the first 17 years of the conference. In recent years, most of the biggest originalist events have been Supreme Court decisions, such as Loper-Bright or Brune. By contrast, in the past year, the Supreme Court has, I think, been relatively quiet about originalism so far. Certainly, the interim docket and its responses to the Trump administration's actions have raised many significant legal issues, but in the main, they have involved judicial organizational issues that have not really turned on originalism. The biggest originalist case from the court in the past year was Trump versus Casa, which involves statutory originalism, albeit from a statute from 1789. Here, the court, in an opinion from former federal courts professor Amy Coney Barrett, held that the traditional equity power, which had been conferred on the courts by statute, did not encompass universal injunctions. The court engaged in an originalist analysis relying on its understanding of the equity power as it existed at the time of the statute's enactment. But in a refrain that has become very familiar, the court stated that while no exact match for universal injunctions was necessary, one did need a founding-era antecedent. To me, what's most striking is that the decision appeared to end, at least to a significant extent, universal injunctions. For many years, such injunctions, despite their peculiar features and their significant departures from long-standing notions of judicial power, seemed a deeply embedded part of the legal landscape. But now they appear to be gone. Perhaps the most politically salient Supreme Court case of the last year was Skrmetti, where the Supreme Court held that a law that forbade prescribing puberty blockers to minors for gender identity purposes did not classify based on sex or transgender status. 3 members of the majority also indicated that if the law had classified based on transgender status, they still would not have subjected it to heightened scrutiny. But in contrast to Casa, there was very little originalism in Skrmetti. Instead, the majority opinion largely relied on precedent and existing doctrine. Even the separate opinions of Barrett and Alito, which concluded that transgender status was not entitled to heightened scrutiny, did not invoke originalism. Instead, both Barrett and Alito relied on Caroline products-oriented analysis. While it's not entirely surprising that the court failed to invoke originalism, after all, it was a 14th Amendment case. Still, this was a case of first impression, especially the transgender scrutiny issues raised by the concurrences. And therefore, one might have imagined that this was a good opportunity for Justice Thomas or another justice to introduce originalist analysis of the amendment, if they were so inclined. But they were not. Happily, Chris Green's paper will address what the Supreme Court did not. One of the originalist issues that has been most talked about is the unitary executive and the constitutionality of independent agencies. Now, while the Slaughter case has not yet been decided, that's really not my primary focus here. Instead, it's the originalist debate that has occurred over the last year, and really over the last generation at least, on this issue. This debate, which has produced significant originalist work on both sides with various positions represented, has generated a tremendous amount of new information and analysis about the issue. as compared to the time when I first confronted the issue back at the Office of Legal Counsel when Morrison versus Olson was decided, way back when, someone studying the issue today will be much better informed. To me, this shows how originalist progress can occur. For many years, one often heard the criticism that one could not know enough to assess the original meaning on a variety of issues. But these days, the common criticism is different. It's that the history does not show a consensus about an issue when the Constitution was enacted. From my perspective, that's a big improvement. It's worthwhile noting why such academic progress might have occurred. Back when the Supreme Court did not really care about originalism, there was much less incentives for scholars to do originalist research since it would not influence the court. But when the court reads and responds to this literature, the incentives are changed, and a tremendous outflowing of scholarship is often generated. Of course, we will see how much the court grapples with this scholarship in slaughter. In the last year, there has also been at least 4 significant books that address originalism and related topics. The first is Amy Coney Barrett's book, Listening to the Law. While I expected to agree with her book, I found it to be surprisingly good. The book does several things, including talk about the court's inner workings, Barrett's background, and the history of the Constitution. But I found Barrett's defense of her own legal approach to be especially well done, particularly in a book designed for lay people. It's a worthy successor to her mentor's A Matter of Interpretation, which I assume Barrett had in mind. Still, I wish that Barrett had not followed Scalia in one respect. I wish she had mentioned the Privileges or Immunities Clause as the source of fundamental rights, rather than relying on substantive due process. The second book is Mark Tushnet's Who Am I to Judge?, which argues against using constitutional theory to decide cases, but instead to do so based on judicial craft. While not arguing only against originalism, I think it's clear that originalism is Tushnet's primary target. Tushnet does raise some important points about the difficulty of applying a constitutional theory, such as his argument that constitutional theories are too simple to handle the complexity of constitutional decision-making. Still, I'm very skeptical that judicial craft in the form of reasoned judgment is preferable to a well-considered constitutional theory. I am quite confident that Tushnet and I would disagree about what reasoned judgment looks like on the court. Jill Lepore's We the People, A History of the United States Constitution is a third book. While I have to admit I haven't read this 700-page tome, John McGinnis and I responded to a shorter version of the book that was published in The Atlantic. Lepore criticizes originalism for making it harder to amend the Constitution, which we found puzzling. An important claim in our book, Originalism and the Good Constitution, is that the constitutional amendment process functions poorly, in part because of non-originalism, and that following originalism would improve it. After all, if the court can update the Constitution, there's far less need to go through the difficult process of amending it. And finally, there is Richard Primus's significant book, The Oldest Constitutional Question, Enumeration and Federal Power, where he argues that the standard enumerationist account of the Constitution's original meaning is problematic. Richard does not claim that his anti-enumeration view is the single original meaning. Instead, he argues that the standard enumerationist view was strongly contested and that practice has been inconsistent with that view. Thus, Richard, like many other critics of originalism, including Tushnet, relies on a lack of consensus and later practice. Obviously, John Harrison's article disagrees with many of Richard's claims, and we'll hear about that later. These 4 books are all important ones. One is by a Supreme Court justice, and the other 3 are either from Harvard University Press or by Harvard professors. They indicate, if we needed more evidence, just how important originalism has become and continues to be. All right, well, we've been doing this conference for 17 years, so I thought it might be time to look back a little at some of the highlights, especially because we have a bunch of newer attendees who were probably in kindergarten when the conference began and missed these moments. For an overview of the first 17 years of the conference, and to see someone age right before your very eyes, take a look at this first clip, which begins with the first conference. We've got a great set of papers and commentators, and so we're looking forward to a really first-rate conference. It's really a pleasure to welcome everyone to San Diego and USD for the 3rd, for the 4th, for the 5th, for the 6th, for the 7th, for the 8th, for the 9th, 10th, 11th, 12th, 13th, 14th, 15th, 16th annual Hugh and Hazel Darling Foundation Works in Progress Conference.
You have an H today?
I love that guy. Unsurprisingly, for an originalist conference, many of the issues discussed in the past year keep coming back. Here is Mike Ramsey at the first conference 16 years ago talking about birthright citizenship, an issue he was going to write about in the future.
But I am happy to be giving a talk on this topic because as a sort of version of applied originalism, I guess I would call it. It's closer to the kind of things that I particularly like to do. Addresses, of course, a significant and discrete issue of great importance today, and that is the question of whether the children of illegal aliens born in the United States are citizens by virtue of the Citizenship Clause of the 14th Amendment.
The first conference also involved a significant discussion about interpretation and construction. Here is Larry Solom talking about the now famous distinction in the careful and precise way that is characteristic of all his work.
On this occasion, what I hope to do is to explicate the distinction. That is, the aim is to get clear on the distinction and why it might be valuable to constitutional theory. I'm not going to be concerned about the implications of the distinction. And I'm not going to be advancing a particular theory, either of interpretation or construction.
At that conference, many of the leading advocates of the interpretation-construction distinction were in attendance, such as Barnett, Balkin, and Whittington, as well as some of the critics. Two of the mainstays of the conference over the past 17 years, Larry Alexander and Steve Smith, have recently retired as law professors. Here from the first conference is Larry Alexander trying, not for the first time and not for the last, to get people to understand original intent originalism as he understands it.
By the way, authorially intended meaning is different from authorially intended applications. And I keep hearing this conflation. Intended applications, what people foresaw as applications, is evidence of, but not constitutive of, authorially intended meaning.
And here is Steve Smith from the second conference drawing out some of the comical implications of these interpretive fights.
There's a kind of standard story, I think, about originalism, which is that in the beginning it was mostly focused on framers' intentions, or, so it was intentionalism. But as it has matured and become more sophisticated, it has moved away from intentionalism to public meaning or textualism or objective meaning or something of that sort. there are still nonetheless very capable defenders of the earlier view, and we are fortunate to have a couple of them with us today. One of them is my colleague Larry Alexander, and as you will hear, Heidi's paper, I think, is largely directed to a kind of sweeping critique of Larry's views. Towards the end, she suggested, I think, that they're not only undesirable but impossible. And Larry's now distributed a little response, which I think suggests that if Heidi's views are right, communication in general is impossible. And I sort of hope that either Heidi's views or Larry's interpretation of the implications of her views are wrong, because otherwise I'm kind of in an awkward position up here right now, I think.
One last clip from the first conference is from Jack Balkin. Jack has been suffering through mistaken views of originalism at the conference right from the very beginning. Here is Jack defending part of his living originalist approach.
How do consequences matter in interpretive theory if you assume that the constitutional plan delegates to future generations? The question of how you think about consequences has to be decided by the generation that's doing the work.
Over the years, we've tried to experiment with various things. For the second conference, we accepted a paper from someone who was not yet an academic. Oh my God, what a mistake. We won't be doing that again. Here it is.
So instead, I'm looking at a question of how the originalist methodology has evolved and whether the kinds of originalist methodologies we have create problems for originalism, both as a theoretical matter and as a practical matter.
Actually, Will did a great job, as he always does. Speaking of young scholars presenting at the conference, here is Steve Sachs at the third conference defending his constitutional backdrops view.
I want to suggest an approach to answering them that I think could be fruitful and I think follows from our existing legal commitments. In other words, I want to identify a set of cases in which we can go outside the text without going outside the law. These are what I call constitutional backdrops.
One of the staples of the conference has been Michael McConnell. Here he is from his first appearance at the fourth conference, commenting on Tom Colby's paper.
This is my first time at one of these, and it's been absolutely splendid. First of all, Tom shows, I think, a very clear understanding of what originalism is. As far as I can tell, there's no caricature in his piece. It's a very accurate, straight, perceptive description of both the practice and the normative grounds for originalism, and that, I think, is really quite admirable. To take on a theory at its best without caricature is a model of what scholarly discussion should look like, and is all too rare.
And I entirely agree with Michael about Tom Colby's paper and Tom's overall participation at the conference. That spirit of neutral discussion is part of what we have strived for. Here's another early appearance, this one from John Harrison at the fifth conference, very elegantly talking about Chris Green's paper on loyal denominatorism.
Well, we're getting toward the end. Themes are beginning to emerge. One of them, of course, is Gettysburg. Since we talked about taking property to create the Gettysburg Battlefield Monument, and of course Gettysburg is central to the 13th, 14th, and 15th Amendments, because had things come out differently there, we would have perhaps the good riddance amendments in the North rather than the Reconstruction amendments.
John's comments prompted a response from Chris Green. Now, I'm not sure if this comes across, but Chris's performance that day was one of the funniest presentations we have ever had. And, by the seventh paper tomorrow, you're a little bit punch drunk from originalism. So that also contributed to it as well.
Acts of secession thereby cause loyal people in the South to forfeit their rights. Yeah, that is an unfortunate fact of war. It's one the court confronts very explicitly in the prize cases. And they say, that's just sort of how it is when you're caught behind enemy lines. You know, Whigs who voted against secession. You know, Alexander Stephens is whining about this after the war. It's like, I didn't want us to secede. I thought we had a right to secede. And once we formed the Confederacy, I said slavery was the cornerstone of it. You know, what did I do? What did I do? So I mean, it's just this, you know, kind of crazy thing. But the laws of war say you can forfeit. You know, the Emancipation Proclamation seized slaves behind enemy lines, even if those individual guys were loyal.
And now we come to the in memoriam section of the presentation. We've had some great scholars who have recently passed away, many of whom were not originalists. First, we had Dick Fallon, who attended the conference various times over the years.
Well, thank you very much. It's just a delight to be here. As Larry said, he was my student many years ago. I am not inside the originalist tent. I was somebody who had grown frustrated at a certain point that originalism just seemed to me to be a moving target. I didn't know what originalism was, what held these people together, and now Larry makes me think that I have seen something really important.
And we also had Fred Schauer on several occasions.
So I could start off by talking at some length about how terrific this paper is, but that would eat into my own time. So just consider it said. It is.
Over the years, we've made a couple of mistakes in running the conference. Sometimes we don't take a paper that, in retrospect, we wish we had taken. Here is one. Although she did not get to participate in the conference, she seems to have done pretty well for herself anyway. While Barrett did not present, other people who did participate have also gone on to bigger and better things. One such person now sits on the Third Circuit.
So I will try to be efficient and get through commenting on this piece, which I thought was a tour de force. If you all have read it, it's a brilliant 116 pages, and it is what I like to think of as signature Perillo, where it goes back and it takes a historical example that one might think of as obscure, or at least for me. I was not intimately familiar with the 1798 direct tax on real estate, but Nick explains it comprehensively. He explains it in narrative form to where it's engaging to read, and I'm left intrigued even knowing more, wanting to know more at the end of the 116 pages.
One of the exciting things about the conference has been watching new developments in originalism emerge, and then seeing how the more senior scholars react to them. Here is one such reaction from the 7th conference.
For some time, originalists have been divided on the proper role, if any, for what has been called constitutional construction. For some, if the distinction between interpretation and construction could legitimate this type of argument, the distinction itself was something to be repudiated. This is what Mike Rappaport and John McGinnis attempted to do with their theory of original methods, originalism. Although I insisted there, and continue to insist, that any approach to construction requires normative justification, I never said, and I do not believe, that judges in the construction zone should engage in case-by-case normative reasoning. Now comes Will Bode and Stephen Sachs with their paper, The Law of Interpretation. I cannot resist analogizing this to two kids trying to get their parents to stop fighting. I tried really hard to resist saying this, but I couldn't resist saying it.
Well, that was some of the highlights from the first 17 years of the conference. I hope the next 17 are just as fruitful.